My name is Joshua Daniels, and today I'll be answering question 3. Is the Australian Parliament a supreme or sovereign parliament in the traditional English sense of the words? So, the Australian Commonwealth Parliament can be described as sovereign or supreme in the sense that it holds legislative competence, but it is not sovereign in the traditional English sense of its words. This is because the Commonwealth is a limited government, because its legislative powers are constrained by provisions in the Australian Constitution, subject to judicial review, and are shaped by Australia's federal system of government. Before we explain that, however, we need to briefly outline the origins of parliamentary sovereignty and how it was traditionally defined. The doctrine of parliamentary sovereignty originated in 17th century England, primarily from what is known as the Glorious Revolution in 1689, where Parliament asserted supremacy over the Crown, and this principle was enshrined in the 1689 Bill of Rights. In 1885, British jurist A.V. Dicey defined parliamentary sovereignty to mean that Parliament has, under the English Constitution, and I quote, "the right to make or unmake any law whatever, and further, that no person or body is recognised by the law of England as having the right to override or set aside the legislation of Parliament." So now we know how it was originally defined. How does that compare with Parliament in contemporary Australia? Well, as mentioned in the introduction, the first reason why the Australian Parliament is not sovereign within Dicey's definition is because it is constrained by provisions in the Constitution. The enumerated powers in sections 51 and 52 of the Constitution, known as heads of power, limit the Commonwealth Parliament to legislating only within one of those powers. For example, the currency and coinage power in section 51 XII, and the defence and military power in section 51 VI. There are also express prohibitions, such as section 116 in the Constitution, which limits Commonwealth's lawmaking power regarding religion, and section 92, which caps the Commonwealth's legislative power regarding trade and commerce. If the Commonwealth legislature exercises power that is not authorised by or contrary to one of these constitutional provisions, it will be invalid. Although this is not the case for state legislatures, which do not need the same heads of power. In contrast with the United Kingdom, which still holds to the traditional parliamentary sovereignty, there is no formal codified constitution to provide such constraints. Furthermore, given that sections 7 and 24 require that Parliament be chosen by the people, there are also implied freedoms that can limit legislative power, such as the implied freedom to political communication outlined in the case of Lange and Australian broadcasting corporations. The federal parliament is also subject to manner and form provisions, which are entrenched special procedures required for a parliament to amend the constitution, and these provisions can bind succeeding parliaments. Section 128 of the Commonwealth Constitution is the main manner and form provision, which requires a referendum to amend the Constitution. There have only been 8 successful referendums out of the 45 total referendums held since the forming of the Constitution in 1901, demonstrating how entrenched the Constitution really is and how much power it holds over the Parliament. In the United Kingdom, however, amendments to the Constitution only require a simple majority of Parliament. The second reason why the Commonwealth Parliament is not sovereign within Dicey's definition is because it is subject to judicial review from the courts, particularly the High Court as the highest court in the land. This is really important in Australia because democratic majorities in Parliament can potentially legislate in breach of human rights in the absence of any comprehensive Bill of Rights in our Constitution, and the fact that Parliament tends to be more politically charged than the courts. Generally, however, judges will only strike down statutes if they have express or implied constitutional authority, regardless of whether the statute seems unjust or immoral, as noted in the case Union Steamship and King. The Constitution sets out each branch of government, the legislature, the judiciary, and the executive. This separation of powers limits the Commonwealth Government by ensuring checks and balances upon each branch. Chapter 3 deals with the federal judicature, and Section 75, subsection 5, gives the High Court specific authority to perform judicial review of Commonwealth laws. An example of judicial review is in the case of Love and Commonwealth, where the High Court invalidated the application of certain punitive deportation provisions of the Commonwealth Migration Act to Indigenous Australians due to their unique connection with the land. In contrast, in the case of Cadnieri and Commonwealth, the High Court effectively submitted to Parliament's broad power by upholding the Commonwealth Hindmarsh Bridge Act, despite the fact that it was arguably discriminatory and detrimental to Indigenous Australians. Nonetheless, Australia's judiciary still poses a greater limitation than compared to the UK, where courts cannot question the validity of an Act of Parliament, as held by the House of Lords in the UK case of Picken and British Railways Board. Finally, the Australian Parliament is constrained because of the federal system. Federalism limits the Commonwealth Government by separating the constitutional power between itself and the state governments. One important rationale behind this is that it provides for the decentralization of power to help act as a check against abuse of power. This separation is specified in the Constitution. Section 51 grants some shared powers between the Commonwealth and the state parliaments. For example, the tax power in Section 51, subsection 2. Section 109 of the Constitution provides for the Commonwealth laws to override state laws in the event of any inconsistency, to the extent of the inconsistency. However, states still have autonomy and cannot be bound by Commonwealth laws where they interfere with the fundamental operation of the state, as held in the case Austin and the Commonwealth. In the United Kingdom, despite there being different countries, so to speak, like Scotland and Wales, there is no federation, and ultimate sovereign power still rests with the Parliament in Westminster. In summary, although the Australian Parliament is supreme within its constitutional limitations, it is not sovereign in the traditional English sense coined by Dicey. Constitutional provisions, judicial review, and federalism ensure that the Commonwealth operates as a limited government, bound by law and subject to checks on its legislative authority. This brings me to the end of my presentation. Thank you for listening.